Hello and welcome. I'm Loveday Hodson and I'm here with Troy Lavers. We're both from the University of Leicester and we've been asked to say a few words about our recently published edited collection, Feminist Judgments in International Law, which was published by Hart in 2019. And we're really pleased to have this opportunity to talk about the book, and thank you for listening. So I guess we'll start by saying a few words about why we thought this collection was needed. So Feminist Judgments in International Law reimagines a number of key judgments in international law from a feminist perspective. So we brought together almost 50 authors to collaboratively rewrite key judgments from a feminist perspective. So it's a creative leap, if you like, and an opportunity to demonstrate how feminist theory could and would impact on international law, and specifically international judgments. So I guess it's playing around with methodology and asking our contributors to imagine they were judges, imagine what their view of what international law could look like from that particular perspective. So it's a really concrete demonstration, like I say, of how feminist theory might work and affect international law. The project itself built on a number of feminist judgments projects that had taken place in the national context in a number of common law jurisdictions, particularly starting in the Canadian context. And I think we could see that the methodology of rewriting judgments offered something potentially really exciting for international law. Troy and I have worked for a long time, a number of years, I think, on teaching and writing about international law from a feminist perspective. And I think we've always been interested in finding ways to break through some of the kind of traditional approaches to international law, to show how international law could be done differently. I guess so the methodology, when we heard about it, seemed to us to offer a really exciting opportunity to challenge some of the male-dominated patriarchal approaches that tends to have influenced the development of international law and our current understanding of international law. So we were really excited about the opportunity of using this method in the international law context. And also we were again building on the work of a number of brilliant feminist scholars who have really laid the foundation for this kind of work, authors like Christine Chinkin and Hilary Charlesworth, who really demonstrated the significance that feminist thinking can have for international law. So our work always owes our foremothers like that a great deal. So we thought that this provided an opportunity to really put in practice some of our thinking. So then it came down to the nuts and bolts of designing a project that would work in an international law context. And Troy, I don't know if you want to say a word or two about how we approached that.
Thanks, Loveday. Yes, I think when we came to look at how we'd like to tackle feminist judgments from an international law perspective, we were I guess, trying to do things in a similar vein, but also trying to be different. And one of the key things we wanted to do was add a bit of innovation. International law is quite different from domestic law. And because of that, we wanted to do something that would be slightly different. And so we added reflection. And this also stemmed from our teaching that we did in our LLM module that Loveday and I teach together. We add a reflection. So each judgment in the book will have an introduction, it'll have the judgment, and then it also has an author's reflection of how they felt doing the judgment meant to them, what kind of challenges they had, what kind of reflections overall they wanted to do. So we wanted to add a space for people to not only act as judges in the judgment, but also reflect on how they felt about it as authors. And so I think that space was very unique when it comes, and innovative compared to the other projects. So we did follow the other projects in that we had an introduction to the judgments, but then we had this new thing, kind of reflection, which I think is quite interesting. Yeah.
It certainly captured the imagination, I think, of our contributors and the people who commented on the book so far. It seems to be one of the features that gets noticed quite a bit, this idea that you can disrupt the style of writing, you can adopt a formal academic style, you can adopt a judicial style, and then a more reflective feminist style. So it disrupts that kind of judicial authority, I guess, which was quite exciting.
And I would encourage people, when you're reading, don't just stop when the judgment ends. Do carry on into the reflection, because you tend to get a feel for the people who went through the experience, because this project lasted several years. So you get a genuine feel once you read through the reflection. Yeah.
The other, Troy mentioned, the other innovation, which was in our project, I think, was the fact that we asked authors to work collaboratively on rewriting these judgments. So whereas other feminist judgments projects have tended to be individual projects, these were written collaboratively among groups of usually 3 to 5 was a typical number for our groups. And what that meant is this was a kind of pluralist approach to judgment writing, and the authors brought their own feminist perspectives to bear, and so really had the experience of what it means to engage with the compromise of writing a judgment, the need to fit these various approaches together into a concrete outcome. So that was quite challenging at times, but also really interesting, and it proved to be a really important aspect of our project, both academically, but also in terms of building a foundation for feminists in international law, encouraging these kind of networks and collaborations, encouraging people to continue their work, which has certainly happened, and also supporting it, provided important support for one another as well, both in this project and in ongoing projects as well. So the collaboration proved to be a really important element of it. It wasn't without challenges, though. It certainly meant the project, as Troy mentioned, this was a few years in the making. It certainly meant the project took longer, trying to organise these groups of authors, and try and bring the work along consistently and make sure we could produce the outcome in a reasonably timely fashion was certainly challenging. Our authors were predominantly based in Europe, but having a global dimension to the work meant that there were also challenges in getting the practical challenges to overcome. But I think Troy would agree that this is an absolutely key element to the project, and what made it such a success in terms of the author's experience, and in terms of what we're putting out there in the world in this publication.
And I also think we wanted to do it collaboratively, because a feminist methodology leans towards the collaborative approach, and feminist methodology leans towards collaboration in general, and interaction and negotiation. And authors in particular, of course, the other unique aspect of this project was that it was a range of courts and tribunals, whereas other projects follow one particular court, usually the Supreme Court in that domestic jurisdiction. We had a range of different courts and tribunals, and the rules where you had to follow the rules of that particular court in terms of like were there dissenting opinions, or were there multiple opinions, or what have you. And so that was quite varied, and keeping everybody focused on that was challenging at times. But it's also about how judges act. So we had a judge come to our first seminar and say, judges have to discuss, judges negotiate, judges have an interaction. And so it's actually more real world to have collaboration in our project. And so we really enjoyed that part of it. Like you said, it could have been challenging at times, but it's more real world than before. And when it comes to the different courts and tribunals and the structure of the book, there's 9 different courts and tribunals. So we didn't just want to have the International Court of Justice. We wanted to have, you know, the European Court of Human Rights. We wanted to have the International Criminal Court. Everybody at first wanted to do either human rights or international criminal law, but we wanted some general international law as well. So the book is divided into 3 sort of chunks of judgments: general international law, and then human rights and international criminal law. So you can find, if you're interested in a particular topic, go to that section. But I strongly recommend everybody try and have a read of the general international law, because you're getting a feminist perspective on things you may not consider to be a feminist area. You know, international institutions, not largely seen as a sort of feminist area of exploration, treaties, customary law interpretation, all these aspects haven't really been delved into, except in small amounts, certainly when it hasn't been delved into when it comes to feminist judgments. So we hope the book spawns more exploration from a feminist lens into different areas. But we strongly recommend you do that, and then read a very excellent conclusion by Hilary Charlesworth, the great Hilary Charlesworth, as well.
Absolutely. Okay, well, thank you for listening, and we hope you enjoy the collection, and we look forward to ongoing engagement with Feminist Judgments.